Probate can quickly cost a family 10, 20, or even $30,000, not because anything went wrong, but just because nobody knew the rules going in. And the trap isn't really one single thing. It's a handful of small, ordinary decisions that turn a 6-month process into a 2 or 3 year nightmare. Hey, and welcome back. If you watched the last video on what happens when you die without a will, you already know probate is the court process that settles someone's estate. Today, we're going deeper. What actually drives probate costs up, why it drags on so long, and the specific traps that catch even families who think that they're being careful. Let's start with the basic shape of it. Probate usually takes somewhere between 6 months and a year for a straightforward estate. That's the baseline. Even when you do everything right, disputes, complex assets, or family disagreements can stretch that into 2 or 3 years. And the reason it takes so long isn't usually because the court is slow, it's because the law builds in mandatory waiting periods on purpose. Creditors typically get a few months to come forward with any claims against the estate, and the clock doesn't even start until the case is formally filed. Nothing about that waiting period can be rushed, no matter how simple the estate looks on paper. Here's the first real trap: rushing to start the process before you're actually ready. There's a common assumption that probate has to begin immediately after someone dies. In most places, that's not true. There's usually a reasonable window to get organized first. But families under emotional pressure often file before they've even gathered the full picture of what the person owned, what they owed, or where the paperwork even is. Starting before you're ready doesn't speed anything up. It just means you're more likely to make a mistake the court catches later, which costs more time than slowing down would have in the first place. That leads into the second trap: incomplete discovery of the estate. This is one of the most common errors that show up in probate cases. An executor misses a bank account, an old retirement plan, or a debt that nobody even knew about. And once that gets discovered, the entire process can grind to a halt while the inventory gets corrected. This is the exact reason the free checklist linked below this video exists. It's not just for people planning their own estate, it's genuinely useful for anyone who's about to become an executor for someone else. Because the number one thing that delays probate is nobody being able to answer the question: what did this person actually own? The third trap is paperwork errors. And this catches more families than you'd expect, especially when people try to handle probate entirely on their own to save the money. Outdated forms, missing local requirements, or a filing that gets rejected on a technicality can mean starting major parts of the process over again, with legal costs adding up and stacking each time. One real example would be a family that skipped a required step of formally notifying creditors, assuming it wasn't necessary for a simple estate. A creditor showed up 8 months later, and the case had to be partially reopened, adding thousands in unexpected costs. Probate has very specific procedural rules, and the rules don't bend just because an estate seems simple. Fourth, asset validation mistakes. Different assets require different validation approaches, depending on whether you're dealing with probate requirements or tax requirements. And using the wrong method can trigger extra scrutiny from the court, potential penalties, and a longer timeline. One family ended up needing formal appraisals they hadn't even planned for, which not only delays everything, but actually increased the estate's tax burden in the process. This is one of the areas where trying to save money by skipping professional guidance can end up costing significantly more than it saved. Fifth, and this is the big one: family disputes. Nothing extends probate quite like disagreement. Will contests, arguments over personal belongings, or disputes about how assets were valued can turn a 6-month process into a multi year one. There's a real case on the record involving three siblings who simply couldn't agree on selling their mother's house. The disagreement alone stretched the process to over 2 years and cost the estate over $30,000 in legal fees. That's money that came directly out of the inheritance. And the attorneys that handle these kind of conflicts will tell you plainly: When a will gets contested, almost everyone loses, even the side that technically wins, because the estate is paying for the whole fight the whole time. A lot of these disputes trace back to one preventable cause: unclear communication while the person was still alive. Families who never talk openly about the plan, or whose wills will contradict what they've told people informally, are far more likely to end up in conflict. So if you're the one that's making the plan, the uncomfortable conversations need to start now because it'll be dramatically cheaper than legal fights later. Sixth, forgetting that beneficiary designations override everything. We touched on this in the last video, but it's worth repeating because it's one of the single biggest probate triggers. Retirement accounts, life insurance, and certain bank accounts pass according to whatever form is on file, not according to your will. If that form is missing, outdated, or contradicts your estate plan, the result is either the wrong person inheriting it or the asset getting pulled into probate after all. Reviewing these forms after every major life change isn't optional maintenance. It's one of the few genuinely free things that you can do to keep your estate out of probate entirely. Seventh, choosing the wrong executor. The executor's job is real work: tracking deadlines, communicating with beneficiaries, managing estate funds, filing accurate paperwork, and naming someone who lacks the time, organization, or even the basic trustworthiness to do that job. Well, it's kind of its own trap. The wrong executor doesn't just slow things down, they can create disputes that wouldn't have existed otherwise, simply because beneficiaries don't trust how things are being handled. And finally, eighth, worth knowing because almost nobody mentions it: probate isn't only something that happens after death. If you become incapacitated without the right documents in place, specifically a power of attorney and a healthcare directive, your family may have to go through a court process that functions almost exactly like probate, just for a living person, in order to get legal authority to make decisions on your behalf. It's sometimes called guardianship or conservatorship, and it carries the same cost and time as probate itself. So here's the actual through line across all eight of these. Almost none of them require anything dramatic. They're disorganization, missed forms, and unclear conversations, as well as outdated paperwork. Exactly the kind of small, boring things that are easy to fix in advance and brutally expensive to fix after the fact. Probate costs can run anywhere from 3 to 10% of an entire estate. Once you value in the legal fees, executor compensation, and the court costs all added up. On a modest estate, that's still thousands of dollars. On a larger one, it's tens of thousands. None of this means probate is something to be afraid of. It means it's something to prepare for, the same way you'd prepare for anything with a known rule or known pitfalls. A living trust, correctly funded with your actual assets, can avoid probate almost entirely for the property inside of it. Joint ownership with the rights of survivorship can pass directly through without court involvement. And simply keeping your beneficiary forms current does more heavy lifting than most people realize. If you haven't already grabbed the free checklist from the last video, it's linked below this one as well. And I would highly recommend you walk down there and grab that form because it's exactly the kind of organization that prevents trap number 2 on this list: the missing assets problem, which genuinely one of the most common and most avoidable causes of any probate process spiraling out of control. If this helped, please like this video and subscribe, because next week we're going to be breaking down another piece of this puzzle. Thanks for watching and take care.